Hello and welcome to Verdictum. I'm Sheetal June, and in today's segment we will talk about the Supreme Court's ruling allowing issuance of tax reassessment notices under the old regime after April 2021. The Supreme Court has finally settled the issue of whether the tax reassessment notices issued after April 2021 during the transitional period marred by COVID-19 pandemic will fall under the new regime or not. In a significant verdict that will have an impact on around 90,000 reassessment notices issued during that period by the Income Tax Department, the court has ruled that the Taxation and Other Laws Act or TOLA will continue to apply over the Income Tax Act after April 1, 2021. The ruling bears importance to the taxpayers who had challenged these notices, arguing they should fall under the new reassessment regime that took effect on April 1, 2021 during the COVID pandemic. It was their contention that the statute of limitation had expired and that the department could no longer issue reopening notices under the previous framework. They averred that the old law's extension was implemented through a circular while the new law was enacted through the passage of the finance bill, which they contended had more legal weight. The genesis of the issue lies in the enactment of the Taxation and Other Laws Act (TOLA) during the COVID-19 pandemic in 2021 to extend the time limit to issue notices. TOLA extended the time limit for issuing reassessment notices for assessment years 2013-14 and 2014-15 till June 30, 2021. This led to an unprecedented overlapping of old and new laws on reassessment, which triggered countless notices and led to over 10,000 writ petitions, many of which were counter-challenged by the tax authorities through special leave petitions before the Supreme Court. The Finance Act 2021 provided a complete overhaul to the provisions pertaining to the statutory schemes of initiating, inquiring, conducting, concluding reassessment proceedings. This included issuance of show cause notices before reassessment notices, extension of scanning period for reassessment from 6 years backwards from the end of the relevant assessment year to 10 years in case of the amount exceeds 50 lakh. Notably, the amendment stated that the assessment years that were time barred under the pre-amendment regime could not be a subject for reassessment under the amended regime. This implied that no notices could be issued for assessment years 2013-14 and 14-15 under the new regime, as the limitation period of the 6 years stood expired under the old regime. A three-judge bench headed by Chief Justice of India D.Y. Chandrachud, however, has now reiterated the Supreme Court's ruling in the Ashish Agarwal case, which allowed these tax notices to be issued under the old regime for the disputed period. Thank you for watching the video. Hope it was helpful. For more such informative content, subscribe to our channel and download the Verdictum app on iOS and Android devices.